Morning. Welcome everyone to the next monthly immigration litigation roundtable with the Amica Center's Immigration Impact Lab. We are very honored to have you with us today to talk all about crimes involving moral turpitude and making challenges to CIMTs after Loper Bright. This training discussion will be led by my colleagues Peter Alfredson and Kendra Blendon from the lab. Are here with us. So how are you guys doing today? Excited to jump in.
Yes, absolutely.
Yeah, welcome everyone, and we're really looking forward to the roundtable.
Yeah, can't wait to get started. Just admitting people as we go, but I will give the intro we always give about who we are, what we do, and then we'll get started. So what is the Immigration Impact Lab? This is essentially the impact litigation shop at the Amica Center. For anyone who missed the name change, we are formerly Care Coalition. We changed our name to the Amica Center in honor of our 25th anniversary this year, and to reflect that we're no longer only focused on the capital area. We are now providing legal representation and doing impact litigation really throughout the 3rd, 4th, and 11th circuits currently. So the lab is where we bring a lot of our cases on appeal to the board and the circuit courts. We do a lot of habeas petition work, starting to do more class action work, challenging detention. And we originally started in the CRIM space, so we're excited to circle back to CIMTs. Here's just a little bit about our approach, how we build impact cases from initial litigation at the immigration court or federal district courts, bringing them on appeal, often through individual cases making good precedent or aspiring to. Before we jump in on this topic on CIMTs, I just wanted to say a quick word, kind of where we're at analyzing CIMTs after Loper Bright, which Peter and Kendra will speak a whole lot more about. This is a very fast developing area. We are really at the initial stages of thinking through it internally, and this presentation, putting this together, was one of our first opportunities to get to really put our heads together thinking more. So we're excited to share our very fresh thoughts with you and hear your thoughts. We're hoping to have some discussion today too about, as a group, as a collective, how we can rethink what the standard could be to propose for CIMTs after Loper Bright. So with that being said, I will turn it over to Peter and Kendra to get started.
Thanks, Adina, and it's great to see everyone, and those of you who can't see on the screen, welcome. I'm really excited to have you all here. I'm Peter Alfredson, Senior Attorney with the lab, and just to briefly go over some of what we'll be discussing today, we're going to start with a very brief history of CIMTs, what they are, how the board and federal courts look at what a CIMT is, and then we'll talk about the recent Supreme Court decision in Loper Bright, how that might change some of the frameworks that both the board and IJs, as well as federal appellate courts, use in looking at CIMTs, some other recent developments in federal court cases that might kind of bode for the future of what we can expect or what we might look out for. And then also we want to have somewhat of a discussion to kind of bring that up with you all in a way where we can also get input from people and brainstorm kind of together as a hive mind, because we have all these smart people in this space together. And then we'll talk about a couple of case studies to kind of tie everything together as we go forward. Okay, and I just want to start off by kind of bring up this point that I think you'll see us return to again and again today, which is that there have been attempts to define CIMTs by both the board and federal courts, but it is this inherently kind of open-ended term that really is difficult to put into a box, which is a way that, unfortunately, the government has often used CIMTs to hurt immigrants, because it really can be used to bring in all kinds of conduct, including things that I think probably most people on this call would agree is not morally turpitudinous or doesn't shock the conscience of society at large, but still leads to people having these horrible consequences. And so we're going to try to really unpack what this means and also not take for granted the definitions that we maybe have been given by the board or other sources over the last few decades. And I think it's important to remember that some of this is illusory, and even when things exist in case law, we don't necessarily have to accept them as a given, and there's always room to argue and push the boundaries, which is part of what we want to do today. And an opening to do that here is this recent decision in Loper-Bright, which we'll talk a little bit more about soon, but it was the Supreme Court decision on statutory interpretation and deference to executive agencies that basically said that agencies, if there are ambiguous terms, don't get to decide what those terms mean. And we think that that presents new openings for what moral turpitude might mean going forward, how courts and the agency maybe might have to be a little bit more flexible about that definition, and we can push for new understandings of what that means. And that's what we hope to discuss today and collectively reach some new understandings about and see what might be possible going forward. And with that, I'll turn it over to Kendra.
Let's talk about where this phrase even comes from. As we're all aware, our immigration system is built on racism, starting with the Chinese Exclusion Acts. And CIMTs are not the only ground of deportability and inadmissibility. Some other statutes make it quite clear that if folks have committed firearms offenses or have committed violent crimes, that they are excludable. But CIMTs emerged as a catch-all for us to be able to exclude other people, and it really became this amorphous standard. It first appeared in the Immigration Act of 1891 for people who have committed other infamous crimes involving moral turpitude. At the time, moral turpitude was a customary legal term, and it was often used in slander cases or for the impeachment of witnesses. But in the immigration context, it became the metric for determining which immigrants have good moral character and who were the quote unquote bad immigrants that we want to exclude. The 1891's act of the phrase CIMT without comment demonstrates Congress's intent for a flexible standard that changed and allowed for the hand selection of immigrants. Subsequent amendments and expansions in 1907, again, didn't define moral turpitude in the law itself. CIMTs have historically been a way to exclude undesirables from the US, including people who've committed crimes like homosexuality, premarital cohabitation, and obscenity. It was also used to exclude people who had subversive political opinions, including journalists and advocates who were quite open about their opinions on what the US should or shouldn't do. For many of those reasons, critics have argued that CIMTs are just this vague catch-all that are rooted in outdated gendered honor culture norms. Even though CIMTs are this vague standard, they still have pretty intense consequences. We have the deportability and inadmissibility grounds listed here. Every non-citizen should be concerned about CIMTs. If you are not a US citizen, you should be aware of these statutes. So always screen for your client's criminal history and determine whether the convictions make them at risk of being removed. At the very end, we have a list of resources, including our Virginia crimes chart and other resources to help you determine whether your client's convictions put them at risk. And so in addition to just triggering removal proceedings, CIMTs can also stop the clock for cancellation of removal, for VAWA relief. It can be a bar to good moral character for naturalization, and it can result in mandatory detention. So it's always important to screen your clients for these issues. And now I'll turn it back to Peter.
Thanks, Kendra. So now that we know how horrible CIMTs and the impact they can have on immigrants are, let's talk about what they are under the current definition. I want to start by outlining what I'll call the core definition of CIMTs, because this is really what the Board of Immigration Appeals for more or less, at least the last decade, but also before that, has said that these points on this slide are what are at the heart of every CIMT. And there's some other things that I'll refer to as the peripheral definition, other language that gets cited and referenced, but these points are really what I think are at the core of that. And that will be important later when we talk about the statutory interpretation issues post-Loper-Bright. So moral turpitude, as the board has explained, is conduct that is, quote, inherently base, vile, or depraved, and that's contrary to the accepted rules of morality and the duties owed between persons or to society in general. And the core of that has really remained in the definition for a long time. They've changed it. So 20 years ago, it used to say between one man and another. So they've tried to make it gender neutral, but the actual language is largely similar. And they've also said that each CIMT requires two essential elements: reprehensible conduct, which is the actus reus, and a culpable mental state, which is the mens rea. There are some circuit-specific differences on what those two prongs look like in practice, but that's something that is required for each CIMT. Beyond that, looking at some other language that is frequently cited, but not necessarily in every board published decision or federal circuit court decision. And that's why I referenced this before as the peripheral definition of CIMTs. We often see this sentence or phrase, conduct that shocks the public conscience, which I think sounds very old-fashioned, but you can also see is somewhat open-ended and hard to define, which leads us into this other oft-repeated phrase that moral turpitude is a nebulous concept. And think about a black hole, a nebula in space that just goes on, for an indefinite amount of time. Physicists don't know how big nebulas are. So it really can encompass all kinds of things. There's no end to that. And in theory, the board has said that there are limits in that CIMTs should be measured against contemporary moral standards and that they can change over time based on prevailing views in society changing. And sometimes the board and federal courts have taken that into account. But I would say that this is not necessarily in the core definition per se, as it's often cited, and that's one of the issues with how this definition has been applied so far. And we'll talk about that more later too. Next slide, thank you. And then finally, most of the time, CIMTs are assessed using what is called the categorical approach. Many of you probably are familiar with this, but I'll just give a brief refresher. So the categorical approach basically involves looking at either the IJ, the BIA, or federal courts as adjudicators will look at the state and federal offense that the non-citizen was convicted of. So they take the actual statute that the person was convicted of. If there are multiple elements that can be divided up of different ways of violating the statute, they will try to identify the specific one that the person was convicted of, and then they will compare that to the generic definition of moral turpitude that I just discussed on the previous slides. And if one of the acts in that offense is not morally turpitudinous, then the offense is not a CIMT. It would be overbroad to being a CIMT. And generally, this analysis is done based on the statutory language, the text of the statute, as well as federal and state case law, including criminal court case law, and not the specific facts or circumstances of the non-citizen's actual conviction. If there's some doubt about what the actual conviction was, they can sometimes the adjudicators can look at what are called Shepherd documents, plea colloquy, jury instructions, other limited types of documents to figure out what that was. And I wanted to say that this is not always the only limitation. In certain cases, for example, for the inadmissibility grounds of CIMTs, there are cases where adjudicators can look at the admissions to conduct that constituted a CIMT, where it somewhat goes beyond just this pure categorical approach, but they're still limited. I mean, the adjudicator still has to look at whether the offense itself would be a CIMT under this approach. Even in that context, they can just look at other admissions to what the non-citizen had done, perhaps without a conviction. So yeah, that's what we're working with and what courts have done.
Next, we're going to talk about two gaps in the BIA's existing CIMT framework that many practitioners, including likely many in this room, have litigated, have tried to point to the board that their original definition that CIMTs are supposed to be for people with one, culpable mental state, and two, reprehensible conduct. But they've led to some of these gaps that have become quite concerning. The first of which is a walking back of the necessary mental state. While crimes involving moral turpitude often involve evil intent, the BIA has said that specific intent to do harm is not required. This came up in the context of child sex offenses, where knowledge of the child's age, even if the perpetrator did not actually know that the child was underage, they're nevertheless convicted because the child's age is a strict liability finding. Why is that problematic? Because CIMTs are supposed to be for someone who knew what they were doing was evil. And so if there's this strict liability finding and there's not a requirement that they actually know the child's age, it raises this big gap that maybe the mental state isn't what we think it should be, a culpable mental state. So that's one big gap in the existing framework. The second big gap in the existing framework, next slide, please, is that CIMTs are supposed to be for these crimes that are so evil, so horrible, that any random person would agree that these acts are reprehensible, that are base, and they're vile. And so they're malum in se. But the BIA has now walked it back a bit and said that the categorization that CIMT should be malum in se is more of a general rule than an absolute standard. So CIMTs can also include regulatory offenses, failures in filling out paperwork, for example. I don't think anyone would agree that just writing something down can be an evil act, but nevertheless, the BIA has said that the failure to register as a sex offender, whether for lack of notice, lack of awareness, or anything else, is nevertheless a CIMT. And so even things like filling out paperwork wrong can be crimes involving moral turpitude. These are two big gaps in the existing framework. And next, Peter's going to talk to us a bit about how federal courts have addressed CIMTs under Chevron, which has since been overturned by Loper-Bright.
Thanks, Kendra. So yeah, just to briefly refresh, Chevron was the framework for statutory interpretation that federal courts used for approximately 40 years before this summer, that essentially said if a statutory term was ambiguous, if it was unclear what it meant, then federal courts had to defer to the agency's interpretations of those terms as long as their interpretations were reasonable, right? So it didn't mean that the agency had absolute blind deference, but if they had a reasonable interpretation, then courts would defer to that. And moral turpitude, as you could probably expect, it's a pretty ambiguous term, so courts generally deferred to how the BIA interpreted that definition. And they recognize the definition that we have discussed already in this presentation, and generally the interpretive framework for doing that through the categorical approach. That didn't mean that courts deferred to the BIA's interpretation of whether every specific offense necessarily was actually a moral turpitude or a CIMT under that definition. So in other words, even if they recognized, okay, this definition is reasonable, it's not reasonable to say that this Virginia statute or that Illinois statute is a CIMT under that definition. And they also would not necessarily recognize through this same level of deference unpublished BIA decisions. So the Fourth Circuit, for example, here you have kind of an example of how that framework was applied. They would recognize BIA decisions as controlling if they were precedential decisions, so published decisions, which the vast majority of BIA decisions are not. They're unpublished, unprecedential, and reasonable. But non-precedential decisions were only given weight to the extent that for federal courts, that reasoning was persuasive. So if it was not persuasive reasoning, they would not defer to it. There were some other circuit-specific differences about how to implement the CIMT framework where courts also refused to recognize aspects of that framework, citing Chevron deference. So one example is that the Third Circuit has refused to adopt what's called the realistic probability test under the Supreme Court's decision in Duenas-Alvarez that essentially would require non-citizens to show that there's a realistic probability that they would be charged with a particular interpretation of a statute in the CIMT context. The Third Circuit said, citing Chevron, that was not reasonable to do in this context, and so that's not been required there. However, there were other things where the Third Circuit has accepted the definition and parts of the framework. And there are a lot of differences between circuits on this, so we hesitate to make blanket statements that, you know, this or that about everything, but this is generally how it worked under Chevron before this year.
Thanks, Peter. So there were a couple initial cracks coming.
Yeah.
And then we had Loper Bright.
Yeah, and Loper Bright, I think many of us were waiting for this. I know it's kind of funny because many of us in the immigration space were happy because we thought this had new opportunities, but otherwise there was a lot of doom and gloom in many other areas of the law. But this is a real sea change for us and for many people who work in any area of administrative law. The Loper Bright decision overruled Chevron in a 6-3 decision that essentially has said that now under the Administrative Procedure Act and other principles of administrative law, if there's an ambiguous term, that courts do not have to defer in the same way that was required under Chevron. They were clear to also qualify, however, that the principle of stare decisis still means that cases that were previously decided under the Chevron framework have not all been automatically thrown out the window. So if there was a prior decision that had relied on Chevron, Loper Bright is not necessarily a special new justification that automatically justifies overruling such a holding. But going forward, courts will, I think, be more skeptical, and that's why this is important. And there will be some deference given under probably something akin to Skidmore deference, which is a looser form of deference where the agency does not have as much flexibility, but the court is also not going to necessarily look at absolutely everything de novo. So circuit courts will still look to what the board or other agencies are doing, but it won't be as blind deference as was previously extended. And that is part of why we think there are new opportunities going forward for some of these arguments.
And why are we so excited about this opportunity? For decades, appointed, non-elected immigration judges and members of the board have been the final say for what is moral and immoral behavior. Now that there's less deference to the BIA on what is morally wrong, we as practitioners have the opportunity to push the needle a bit and question whether immigrants really should be removed from the United States for things like minor marijuana possession charges, for petite larceny and minor theft offenses, for regulatory offenses like filling out paperwork wrong. Are these really the types of things that we as a society think are so immoral, so evil, that it justifies separating families? So next we're going to talk about some ways that even before Loper Bright, the board started pushing the needle. And again, when you zoom out and think historically about how CIMTs have went from being this really big catch-all to exclude people who lived non-traditional lives, it's now become a smaller and smaller pool of crimes, to the point that maybe CIMTs as a legal definition are no longer useful to us. In just a moment, we're going to open the floor, so I encourage you to start brainstorming what you think we should do next. But first, let's talk about some pre-Loper Bright decisions from the board indicating how they think morality is starting to change. In Chavez-Alvarez, they held that a conviction for sodomy, aka for being in a gay sexual relationship, is not a CIMT because per Lawrence v. Texas, being gay is perfectly fine. And that type of behavior is protected by our constitutional. It's a human right to love who you want to love. And so if a law is unconstitutional, a law prohibiting gay sex, then that action cannot be a crime involving moral turpitude. They held that it violated equal protection to criminalize gay sex. And so not only are gay marriages prohibited, but just engaging in a gay relationship should not be a crime involving moral turpitude. In Walcott v. Garland, the Ninth Circuit realized, partly by using polling data and the legalization and decriminalization efforts, that public perception of personal marijuana use has changed. It's no longer this evil, cruel, seedy activity. It's something that helps many people, especially those with medical conditions. And so the Ninth has held that marijuana trafficking offenses are not CIMTs because our public's perception, our public moral standard for marijuana has changed. And one big rule that we've learned from Walcott is that polling data and legalization and decriminalization efforts will be considered by the federal circuit courts moving forward when we want to think about pushing the needle. And so next, let's open it up and think, if you were drafting the new CIMT definition, what would you emphasize? Or said other word, how can we as a society define and measure our contemporary moral standards? What would a new CIMT standard look like to you? And we invite you to come off mute or raise your hand, but we're really hoping that this will be a good opportunity for us to brainstorm together.
We'll give folks a second to collect their thoughts, but just to get the conversation going, something we've been talking about and just thinking through is how to handle offenses that are not, clearly about causing extreme bodily harm, but things more like theft and fraud. That's where we kind of got a bit caught up in this analysis. And it's sort of a trap question that we're asking you, right? Because there's also arguments about how CMTs are void for vagueness, right? And maybe we shouldn't be using this label at all. But we also know that is a bit pie in the sky, and we are long away from that, and people are being facing mandatory detention and deportation right now and every day due to CMT's grounds of removability. So just thinking about those of you who are making crim challenges in immigration court at the board, like what's a way we can start pushing back a little bit, leveraging low burb, right? And you might not have the answer now. It could be a rhetorical question too, but feel free to share any thoughts coming up. And Kendra and Peter, do you maybe want to start with what you're thinking about or other points we've been discussing internally?
Yeah, and I think we'll get to this in a bit, but I think it's really important that we try to think about how we measure, who decides what is moral or not? How is that reflected? And obviously these things change over time, right? I think our grandparents' generation had a different understanding of morality, and our grandchildren's generation certainly will than what we have today too. So how do we measure that? And how can this definition and the tools and the types of evidence that adjudicators use take that into effect? And I think that's what I've tried to consider in the course of this presentation, and also more generally thinking about this over the last few months. So yeah, that if that's a little bit narrower of a question for people to consider, I'd invite any answers to that in particular. And yeah, there's no right answer or wrong answer to this, right? That's part of the fun, but also the challenge of it. So feel free to, yeah, just share any thoughts. No one will judge you. Or yeah, we won't judge you at least.
I lean towards thinking that the CIMT definition is void. I mean, especially in a country that's made up of people from different religions, different countries, different cultures. It's impossible to think of American morality as a monolith. And so I think I personally would love the CIMT statute to be removed completely and maybe expand the clear list of other deportability grounds, right? It includes other things like firearms offenses, violent crimes. Maybe we expand that to be a little bit more specific to include other things that we do think are harmful, especially where someone has been injured, physically injured as a result of the crimes. But I think it's impossible to really have this catch-all definition. It's really difficult.
Yeah, absolutely. Or even just go with there's more than enough grounds of deportability already, right? Like it can be so duplicative and yeah. But hopefully this is at least planting a seed for you all to think about for your next CMT case. I know it's some big questions we're asking. So no worries if nobody has initial thoughts, but again, feel free to pop stuff in the chat as we continue or throughout the convo if you have some ideas develop.
With that, I think this point will hopefully be something that gets people's creative juices flowing a little bit more. I wanted to highlight a recent case that I know Ben is on this call, so in a moment, I'm happy to turn it over to you, Ben, if you'd like to say anything. But this was a case that I had helped with some of the moots for, and I think was a really excellent case where a lot of great arguments were being made, and it didn't necessarily turn out the way that those of us working on this case had hoped because there wasn't a great panel. But I think this case was an example of the types of arguments that we think can be made in other cases going forward to push some of these points in other CIMT cases. So this was a case that at the Fourth Circuit had been challenging whether the Virginia solicitation of prostitution offense was a CIMT. And Ben had been the attorney, and then there was also amicus from the Sex Worker Project, and then the University of Maryland's Federal Immigration Appellate Clinic, headed by Aditi Prabhanathan. And in this case, there were a number of arguments about why this offense wasn't a CIMT, but they centered in large part on thinking about why morality around sex for hire has changed over time so that this is really not considered immoral by a majority of people in society in a way that it would have to be in order to constitute a CIMT. And there were a lot of great pieces of evidence that were cited in making that argument, including not just polling data on prostitution and changes to the law around this in other jurisdictions in the US and in other countries, but also interesting examples of least of the act situations between two consenting adults where one had paid for sex. For example, if a person with a disability had hired a sex surrogate, and even there was even a citation to a Seinfeld episode. So there are really a lot of great examples of thinking outside of the box of how to make these arguments that were put forward in this case. And yeah, next slide, please. Unfortunately, there was a really bad panel. For those of you who don't do federal appellate litigation and oral arguments, you find out in the Fourth Circuit, at least, the morning of the argument, who the three randomly chosen judges will be that hear your case. And even though the Fourth Circuit is generally quite progressive, there were really two of the very worst judges on this panel. And so they did not, unfortunately, grant the PFR in this case. But we think that if there had been a better panel, it probably could have turned out differently. And the conclusion that this 83-year-old judge who wrote the decision wrote that there's this societal consensus on paying for sex to be wrong or bad. I don't I don't think was an inherent outcome of this, but and even though that's what happened in this case, I think that the underlying arguments that were made in this case are things that can still be applied as really viable challenges going forward. And I think there are two ways we can do that post-Loper-Bright. First, I think challenging the current definition of CIMTs as unreasonable, and in large part doing so because by arguing that that core definition has to include a part that says that as morality changes in time, that needs to be taken into account for what a CIMT is. Because the current core definition really does not account for that. It's often discussed, it's considered, but I don't think that as it's applied now, that's part of the core definition. And so I think making the argument going forward that as a reasonable means of interpretation, that has to be considered as something that we as advocates should do. And then in the alternative, even under the existing definition, I think we can also still argue that offenses, specific offenses under that definition are not CIMTs. And there are a lot of ways that we can do that. Polling data, using amicus from public interest orgs like us at the Amicus Center or other organizations that represent impacted clients, including non-immigration organizations that work with people who are sucked into our criminal justice system or who are in poverty or otherwise impacted by racism or other forms of marginalization. And then I think also we often think about making these arguments at the IJ level as kind of a legal exercise where we're only looking at state case law and maybe what state Supreme Courts have said about this or that statute. But I want to encourage people to think outside of the box a bit about, just like if you had an asylum case and you were looking at evidence of social distinction for a PSG, for a particular social group, you would look at country conditions evidence, right? News stories and maybe an expert report about how in this country people think about what a PSG is, that they recognize this group in a particular way. And I would encourage you to also bring in evidence like that when you're arguing that an offense is not a CIMT. Talk about not just state case law, but how is this offense seen in the local media? What are things that polling data have shown about that? How is it really in the real world beyond just these state Supreme Court decisions being treated? And I think that that is something that can be considered in terms of, even under the categorical approach, whether something meets this generic definition or not. And so I would encourage us as practitioners, especially the majority of you practice in immigration court, I think, that's something you can do at the IJ level. It's actually much harder on appeal to bring in evidence like that, even on amicus. So that's really, I think, where the front lines of this battle will be fought going forward. And that's a way that as practitioners, you all can make some of those arguments in your own cases. And with that, I wanted to, yeah, just not to put you on the spot at all, Ben, but if you wanted to say anything, because I know you do probably more CIMT Fourth Circuit work than anyone, and we all respect your work so much. And yeah, no pressure at all. But yeah, if you wanted to just add anything, I wanted to turn it over to you for a moment. No pressure.
Yeah, no problem at all. And my internet cut out for a few minutes, so apologies if this was discussed. I just wanted to touch on the point about Loper-Bright and its discussion of stare decisis and whether decisions that relied on the Chevron framework are still viable. So when you read the decision, it seems like it pretty clearly says those cases are still good law, even though they relied on Chevron. But I think logically, the Supreme Court was only referring to its cases. It wasn't referring to cases decided by circuits that relied on Chevron. And I think that's just because of kind of the nature of how stare decisis works at the Supreme Court versus the lower court. So the Supreme Court, it's the nation's highest court, so it can do whatever it wants. There's no higher court telling it got it wrong. So at the Supreme Court level, there's only what's called horizontal stare decisis, as opposed to vertical stare decisis, which is the concept of, the Supreme Court says A, so if the Fourth Circuit said B, then, well, any decision saying B is no longer good law. The Fourth Circuit has to follow the Supreme Court. So I think that's why when the Supreme Court has said in many cases that when that what stare decisis means is we don't overturn a prior decision just because we think it was wrong. We only do so when there is a special justification. Like the rule proved completely unworkable, or something like that. But at the circuit level, that concern doesn't really apply. From the vertical stare decisis standpoint, if the Supreme Court issues a decision that makes clear that what the circuit said is wrong, the circuit doesn't need a special justification to overrule itself. It has no choice but to overrule itself. Otherwise, it would be in conflict with the Supreme Court. And even from a horizontal standpoint, when the Fourth Circuit, one Fourth Circuit panel cannot overrule another, but on occasions when the Fourth Circuit goes en banc to consider an issue and the Supreme Court hasn't spoken on that issue, the Fourth Circuit doesn't say, oh, we need a special justification to overrule what a prior panel held. It just reviews the issue and reaches whatever it thinks is the best decision. So, I think for those two reasons, there's a very good argument that paragraph in Loper Bright, it's the third to last paragraph of the decision, only applies to Supreme Court decisions. I think maybe Chief Justice Roberts, who wrote the decision, was trying to be a little bit vague so that to head off challenges to circuit court decisions. But I think logically, really the only way that paragraph can be read is to just apply to Supreme Court decisions that relied on Chevron. So I think what that means is, let's say there is a Fourth Circuit decision that relied on Chevron in finding a certain statute to be a CIMT. I think there's a good argument that decision, even if it's not, it may or may not be wrongly decided, but since it relied on Chevron, that question is subject to litigation. That a new panel, if that same issue came in front of a new panel, it would not be bound by the prior Fourth Circuit decision, because again, the prior decision relied on a framework that the Supreme Court has overruled. And if you're litigating an issue like this at the Fourth Circuit, the line of cases you want to rely on are those that say that one panel doesn't have to rely on a prior panel decision if its holding or reasoning is untenable in light of intervening Supreme Court decisions. So if you search in Lexis or Westlaw, Fourth Circuit decisions for, Supreme Court in the same sentence as tenable or untenable, you'll find a whole bunch of cases setting that out as the test. And then you would say, okay, well, this prior decision that found under Chevron that this statute was a CIMT, its reasoning is no longer tenable. So the panel that decides this case has to decide the question anew.
So do you think that even if there was a prior, for example, Fourth Circuit decision saying this Virginia statute or this North Carolina statute is a CIMT, in theory, this is enough of a sea change that that is no longer tenable, and courts will look at this with somewhat fresh eyes?
Yeah, well, that's the argument you need to make. I mean, the Fourth Circuit itself has not yet interpreted this language from Loper Bright, but that's the argument that you should make. That basically it's again an open question, because if the decision deferred to the agency, there's no telling what conclusion it would have reached if it had not deferred to the agency. I have a case right now. It was Solis Flores versus Garland. That was the decision that came out in late 2023, holding that Virginia receipt of stolen property is a CIMT, deferring under Chevron to the board under that. Now, in that case, I actually filed the cert petition asking for the court to vacate the decision and remand if Chevron was overruled, and that's what ended up happening. So that case is back at the Fourth Circuit. So in that particular case, the prior Fourth Circuit decision was wiped off the books. It was vacated. So it's no longer even precedent. But for example, had I not filed the cert petition, I would argue that issue remained open, and that a new Fourth Circuit panel could review it with fresh eyes. I think in the types of in issues that you have Solis Flores up on the slide there. The other one right below it is Chavez versus Garland. That's a case that I'll be arguing on October 31st on whether Virginia larceny is a crime involving moral turpitude. And so I briefed that case before Loper Bright, hoping that Loper Bright would come out the way it did, and lo and behold, it did. But the issue in that case is whether pennant larceny in Virginia is a crime involving moral turpitude. And the government's entire brief basically relied on Chevron, saying, it's not unreasonable for the board to say that larceny is a CIMT, regardless of how small the amount of property is. But now that Chevron's gone, that's not enough. The court's going to have to decide for itself whether it is, quote unquote, reprehensible to steal something that's in Virginia. Larceny covers property that's worth less than a penny. So the Fourth Circuit will have to decide for itself whether that's a CIMT.
And have you already, I assume you've submitted some kind of letter to the court or other supplemental briefing? Do you know what the government has said yet?
So I didn't, just because I know the panel is going to be aware of it. And I don't want to give the government a hook to try to come up with some counter argument. So the government actually last week came to me on its knees saying, oh, would you agree to a joint request for supplemental briefing in light of Loper Bright? And I said, no, just because, I mean, the benefit to me of making the court aware of Loper Bright is far outweighed by the benefit to the government of trying to come up with some alternative argument for why, because what the government should have done in that case was argue in the alternative why pennant larceny is a CIMT even without Chevron. But they didn't make that argument. And I think they now realize, oh man, we should have made that argument. So they want to submit supplemental briefing. So in this particular case, I didn't submit a 28J letter or move to submit supplemental briefing just because, the court already knows that Chevron got overruled, and that's something, I can remind them of an oral argument if need be, but I didn't want to give the government an opportunity to try to come up with some alternative argument.
No, that makes sense, and I think is a wise strategy. But yeah, I'll definitely be tuning in to that. Do you know what day specifically, so people can mark it on their calendars to listen?
Halloween.
Okay, wow, that bodes. Yeah, I hope it's not too spooky for you, but very spooky for the government. So yeah.
Thank you so much, Ben. I mean, we so greatly appreciate your brainstorming, your creativity, and we're really looking forward to seeing what the Fourth Circuit does with these two cases in light of Loper Bright. I think this is an extremely exciting time to be an attorney, period, but especially being an immigration attorney when so much of our immigration system has relied on the Board of Immigration Appeals kind of being the final say with Chevron deference. And now with Loper Bright, we're opening all these avenues to litigation, not just in the CIMT context, but also for the BIA's definition of conviction, for their definitions of particular social group, one central reason. And so we encourage you all to be introducing polling data, the amicus briefs, everything else that Peter mentioned, to preserve that evidence on the first instance when you submit these cases to the immigration court. On the Amicus Center website, we also have some draft briefing and some supplemental briefing on issue preservation, so that you can be sure to preserve these issues on appeal. And again, Loper Bright, even though it gets rid of deference, the circuit courts are still allowed to look at the BIA decision, but they're not able to just quickly defer. They have to see whether the BIA's reasoning was strong. And so especially if you get BIA decisions on CIMTs that are brief, that do not have many legal citations, or if you think there's some type of logical fallacy going on, those are the cases that we're particularly interested in taking up to the circuit courts. We encourage you all to litigate, and of course we hope that you'll come to us so that we can consult with you and collaborate on whether things should go up for petitions for review to the circuit courts. Next slide.
Yeah, as Adina mentioned in the chat, we'll be sharing tomorrow for everyone that registered sample briefing for Third and Fourth Circuit law, and we will have at some point in the near future for additional circuits, hopefully. But this is something that, as you'll see, you can customize and adapt it to your cases, but there are some templates that you can use that give you a chance to plug in some of these arguments for it's hard about this topic to have very much of a general thing because it's obviously very specific to your particular statute. And so you'll have to do the research and make the arguments, but we're happy to help and hope that this will be a resource you all can use going forward.
And we'll open it up for questions in a moment, but just want to flag the next roundtables coming up. We've got 3 more for the year. So October is on habeas. November, we'll be circling back to Loper Bright to talk about particular social group challenges, including on mental health claims, TAMU, and then December 5th on due process and access to immigration court records. So open it up to the floor. I know we had a few folks share over the chat as well. Molly, thank you for being here. Molly from the Sex Workers Project. We appreciate you being here, and thank you, Suchi, for sharing a suggestion about possible rethinking of the CIMT definition. I'll read that out for folks. So she said, agree with everything you all said about CIMTs being a nonsense category, but one way to frame it in the interim could be to tie to what state legislatures have deemed to be particularly grave offenses as measured by how long criminal sentences can be, and arguing for only things that have really significant sentences. Of course, this runs into all the problems with the criminal legal system, but at least it's somewhat objective and avoids some de minimis conduct. So
I think
that's
that's a
what
good point because, as you all may know, for example, for the CIMT deportability ground, the possible sentence has to be longer than 1 year, right? And many offenses where in practice people may very rarely be sentenced to anywhere close to that in practice, but you know, the possible range of sentence might be like 1 year to 15 years or something. So then it still gets swept into that. And so unfortunately, this is a problem with how the statute has been written by Congress, but it didn't read that way before 30 years ago. There's no inherent rule that it has to be forever. And so even if Congress might have to be the ones to change that, I think this is a good kind of reminder that we shouldn't necessarily take these things for granted and I mean, it might be the rules now that we kind of have to operate under, but we shouldn't accept these as things that can't ever and won't ever change necessarily, even if we can't get a court to per se overrule that from Congress. But yeah, we should continue to question these types of things and expect our leaders to change these rules eventually. It really is, you know, it's really hard to understand how we're working under the same set of rules for 30 years that have clearly not been functioning. And anyway, I can only hope that they will change again in our lifetimes for the better.
Thank you, Peter. Does anyone have questions for us in the last few minutes or want to share a reflection? One thing I just keep thinking about too is the role of discretion in so many immigration cases too. I think this is something we can point immigration judges to the extent they are, you know, concerned about morality and wanting to use the CIMT ground as a hook for that, reminding them that's what discretion is for, right? And helping judges think through the differences between moral judgments, which are very subjective and differ from person to person, versus, you know, values and versus the other laws and criminal laws we already have to penalize people for acts that are done. So I think there's a larger call to action too we want to make to just really use Loper Bright as a hook and as a renewed reason to push back and defend our clients in immigration court and not allow the CIMT ground to be just something we accept as a tool to deport people. Any final thoughts, Kendra, Peter, before we wrap up?
No, just again, it's an exciting time to see if we can close this gap, if we can make the realm of CIMTs even smaller. And definitely encourage you all to take a look at our resources. And as always, like we're here and very excited to talk about these cases with you. So thank you so much for being here and for sharing your input and your thoughts, and we'll keep talking.
Yeah, thank you all so much. And please share this presentation with other people who you think might appreciate or benefit from it. And I just want to reiterate that the changes to this and the advances that we make are going to take cooperation between both people doing impact and appellate litigation as well as people working in immigration court. We need to continue to cooperate and plan these strategies out together. So we encourage you all to not only be in touch with us, but other organizations that are doing this, and practitioners like Ben who are working in appellate forums, but also yeah, and those of you who are on this call perhaps that do appellate litigation, keep talking to people doing this work in immigration court. And I think together we'll be able to build better records and stronger arguments to make some of these points in cases going forward.
Thank you for a great presentation, Peter, Kendra, and thanks, Ben, for your comments and everyone who participated in the chat. We'll see you October 3rd, same time, to talk about habeas petitions and federal court. Thanks, everyone. Take care.